Okay, doctors, we're going to get started. Good evening. Good to see everybody. Thank you for taking the time to come into the presentation tonight on the Doctors Council Legal Service Plan and legal topics. We're pleased to see you. Before we start our presentation, I'd like to turn it over to our president, Dr. Frank Proscia.
Thank you very much, Kevin. Do you hear me okay?
Loud and clear.
Great, thank you. Hi, it's great to see you all here. I wish we could be together in person, but unfortunately we can't. As you know, each and every year on March 30th is National Doctors Day. This day, though, is going to hold a more solemn place in our hearts from now on because of how it affected us and our families. The stress and trauma we have all endured will be with us a very, very long time. What doctors accomplished is truly short of miraculous. Much of the stress was due to maintaining your team's focus and moving forward in very exceptional circumstances. It is so true. We are truly greater than the sum of our parts. I just want to say how proud I've been for all of you for what you did, regardless of how or where you practice your profession, not just for this past year alone, but for every single day moving forward. I hope you all received my email earlier today about the Doctors Day event we held in Elmhurst to thank all the doctors and to memorialize all those and to memorialize and remember all those that passed. I wish you all a happy Doctors Day each and every day. From the bottom of my heart, I thank you. I truly thank you for everything that you do. Thanks.
Thank you, Dr. Proscia, for those comments. And I would like to also join Dr. Proscia in wishing each of you and your colleagues and your families a happy National Doctors Day, but what that means in terms of your commitment to every single day and the sacrifices you've made in the last year. So thank you. So for tonight, we have a presentation on the Doctors Council Legal Service Plan and also covering legal topics that we mailed and emailed out. Thank you, those of you who took the time to send in some questions. We will get to your questions. If you have further questions as the program proceeds, please feel free to send it to me in the Zoom chat. If there's time permitting at the back end of the meeting, we're glad to go through them. If not, we'll circle back to you. When you send me the questions, please put your question, but also put your name, just in case we can't get to it tonight, we will circle back to you. We'll make that commitment. And we are pleased tonight to be joined by 5 different attorneys that we have from the firm that we use. And we have used this firm for not just years, but for decades. They worked well with us, worked well with our members, and that's Pryor Cashman. They have been with us in terms of representing the doctors at work, in bargaining, and grievance and arbitrations, as well as through the legal service plan. So we thank them for taking the time to share this evening with us and to give us the benefit of their thoughts and their experience. And without further ado, I'll turn it over to Richard Bethel from Pryor Cashman to introduce himself and his colleagues and to start tonight's program off after that in terms of explaining the legal service plan and moving from there. Thank you, everybody. And Richard, please take it away. Richard, you're on mute. So.
Is that better? I hope so.
Yes, it is.
Thank you, Kevin, and thank you, doctors, for joining us tonight. As Kevin said, Pryor Cashman has a long history with Doctors Council. Indeed, I have a long history with Doctors Council. I've been working with Doctors Council now for almost 40 years. I've asked 4 colleagues to join us tonight to both offer you some insights into the areas of law in which they individually practice, but also to provide an overview of the legal services plan that we have offered to Doctors Council for, I believe, something approaching 35 years at this point. Let me start with the 4 colleagues, just so you know who they are. The first one who will speak is Barry Landsman. Barry, can you say a few words about yourself? Barry works in the real estate area, but I just want his image to appear on the screen so you know who he is.
I should be on the screen. Can you hear me?
There you are.
Great. It's nice to be with everybody tonight. Although I don't share the same history as Richard, I'm close. I've been working with the Doctors Council, handling the residential real estate for Prior Cashman for the past 20 or so years. And so most of the residential real estate transactions for Doctors Council will come to me at some point. And for the most part, I would be the person that would be handling them on your behalfs.
Next, I want to introduce Richard Kay, who has long been working with Doctors Council members on trusts and estates. Richard, can you say a couple of words and introduce yourself? Now, I know Richard is here because he was speaking before the program began.
Can you hear me now?
Yes.
Okay, great. Thanks for the introduction, Richard. Yes, I've been involved with the Doctors Council representing physicians and related personnel for much too long for me to even think about, probably 30 plus years. And it's been a remarkable experience. And I have personally been delighted in the interaction that I've achieved with a whole variety of physicians from all over the world. It's been a very enlightening experience for me personally.
After Richard makes his remarks in his area later, Elizabeth Warner will speak next on the matrimonial area. Liz, could you say a couple of words to introduce yourself?
Yes. Hi, good evening. Thank you for having us. I have been at Prior Cashman in the family law group for a bit over a decade now. And from time to time, we have taken on various matters for the Doctors Council that arise mostly in the divorce context, but obviously we also do child support and custody agreements and all manner of family-related matters. So happy to delve into that a little bit with you all tonight.
And last but not least, Steve Rabinowitz.
Hello, everyone. I'm another one of the long timers. It's been about 30 years that I've been working with the doctors, and I'm the last person you want to have to call, because I'm the person that you call when you're in trouble, when something's gone terribly wrong and your license is in jeopardy, you're involved in some form of investigation, and my job will be to defend you. And I'm happy to say that I've been very successful in that over the years, and have kept a lot of doctors out of trouble. I've saved their licenses and helped them steer through some of the more stressful times in their lives.
Thank you, Steve. Let me say a few words first about Prior Cashman, and then I want to move on and do a quick review of the services we provide under the Legal Services Plan. I'm happy to say that Prior Cashman, over these many years of involvement with Doctors Council, has grown. And we're now up to about 180 attorneys, the overwhelming majority based here in New York, which means we're among the 200 largest law firms in the country. We're among the AmLaw 200 at this point, but it really hasn't changed the way we practice, and I'm very pleased about that as well. Turning to the Legal Services Plan, we're very proud of the Legal Services Plan because, frankly, I think it's, to my knowledge, unique. I'm not aware of a comparable law firm offering a similar legal services plan to either a union's members or, for that matter, to anyone else. The Legal Services Plan works on an insurance basis, with Prior Cashman, in effect, incurring the risks in the sense if there's a tremendous number of real estate closings this year because the interest rates are low, we'll do more of those. And we generally will not get paid substantially more at all. But it's a plan that's worked over all these years. It's primarily funded by employer contributions. So the doctors are paying a very small part of our fees here. These are employer contributions that are, of course, obtained through collective bargaining. The collective bargaining agreement requires the employer to pay into the legal services plan or into a benefit plan that then pays into the legal services plan. And we're really able to provide first-rate representation to doctors at a fraction of the cost paid by you. And that's really the key to it. Let me take a few minutes to go through the major services we provide here. And this really is laid out in detail in the document that I know was sent to you with the invitations for tonight. That's the legal services plan description. If you lose it or don't have it in the future, it is always there for you on the Doctors Council website under benefit funds. And it's right there in the middle of the summary plan description for your benefit plan. So it's always there for you. I see Kevin has put it up on the screen. I'm just going to go through it quickly, just as an overview. Now, taking real estate as an example, just to demonstrate what the contract and the contributions from your employer have done for you. The average closing that we do, that Barry does, or that other attorneys in our firm do, takes maybe 20 to 25 hours of attorney work. We bill on average in the $12,000 to $15,000 range for that closing. The same representation is provided to you under this plan for $575 for the first transaction, plus expenses, whatever you have to pay for whatever it might be, that you will have to pay on your own, as you would whatever attorney you use. Now, if you do two transactions, like a buy and sell, as many people do, the second transaction would be for $650. Adding those two numbers together, for $1,225, you would both be able to purchase and sell a real estate property, as long as it's your primary residence. That's really the primary restriction here. This is not for commercial properties you may invest in or something like that. Those can be covered in the legal services plan as well, but not under this particularly low price. Other popular legal services are also provided for fixed rates. The next one that I'm going to mention only because it's the next one in order in the plan, is under the matrimonial or family law area. An uncontested divorce we will do for $750. Now, there's a caveat there, and I want to mention it so that nobody misunderstands. I will tell you candidly that there are not many divorces that are truly uncontested. For the most part, there are issues that have to be negotiated. There are often issues of custody and support. So some are done at this flat rate, many are not. But that's an issue you can take up with the attorney in the family law area who will be representing you. And that person will explain to you, as Liz will be happy to tonight, the details of what I'm saying. Now, if the divorce were to be uncontested, the first two hours would be without charge to you, and the next 50 hours would be charged you at $200 per hour. So this is quite a discount, given that our regular rates, for me, for example, although I'm not in family law, my regular rate is about $900 an hour. So $200 an hour is a substantial discount. The third primary benefit here, or option here, is the general consultation. This is the catch-all. It fits everything. Anything that's under New York law, we will cover under this. The first 2 hours are without charge. So if you just happen to have questions about some area of law, if you can identify the area of law, we'll try to fix you up with an attorney who specializes there, and that person will be available to you for up to 2 hours to try to answer your questions or frame your issues as you see fit. If the issue goes beyond there, for example, many litigations or some other matters, the next 50 hours are at that discounted rate of $200 an hour. As I said, this is any matter under New York law, but the legal service plan is limited here to New York law issues or federal law issues in New York. The fourth area that I want to highlight is what Steve Rabinowitz was talking about, or it's one part of that. It's state license proceedings. And that's something that wasn't in the plan at the beginning, but it's evolved because we found that not often, but from time to time, doctors would have issues with their licenses. And we broke it out because technically the city, which was the initial contributor to these plans, expressly provided that anything that arose out of city employment could not be brought under this plan. We haven't told them about this, by the way, But I don't think they'd object that if a doctor has a license issue, even if it arises out of your doctor's council represented employment, we will cover it here. Again, at these 50 hours at $200 an hour. The fifth area I want to mention is estate administration. And this has to do with, unfortunately, someone in the family has passed. We're now talking about how we administer the estate. This is the area that Richard Kay is very expert in, as are others in the firm. And here, the first 5 hours are without charge. And then we offer 25 additional hours at that $200 per hour rate. The sixth area I want to mention is estate planning, also within Richard's bailiwick. There, and this is very popular because everybody should have a will. Everybody should at least talk about whether they need a will. I know some people think they don't because they'll live forever, but it doesn't usually happen that way. And here we have a fixed rate of $400 for a member, a spouse, or a domestic partner. If you do two of them concurrently, that is with your spouse, it's only $800. This is a huge discount from what we would charge, or almost anyone else would charge for this service. Let me talk for just a moment about exclusions from the plan. As I said before, the plan, with the exception of the license proceeding, does not cover anything arising out of your doctor's council covered employment. And that's true for two reasons. One is the one I mentioned before, that employers didn't want to pay us to sue them. But the second reason here is that employment-related disputes are really ones, that representation, you'll have us on anyway, but you'll have it through doctor's council. It'll be left up to the union how to use us, when they need lawyers, when they don't need lawyers. But that's much of what I do. It's a good part of what Steve does and what several other attorneys do in the firm. I'm only going to talk for a couple of moments about the out-of-state legal service plan. If your primary residence is outside New York State, generally, of course, now Connecticut and New Jersey, you're automatically placed in an out-of-state legal services plan. This provides much more limited services, up to $600 reimbursement for legal services provided by an attorney you choose, anybody you want, licensed in that state, for either preparation of will or real estate closing. Now, if you have reason to believe in a particular year that you're going to need representation under New York law, you have the right, prior to the beginning of the plan year, to opt into the legal services plan by, in writing, an email I think will suffice, to the fund administrator of the welfare fund or the benefit plan, advising that person that you wish to be included in the in-state legal services plan. You will then not have the out-of-state representation at $600, but you potentially may have much greater representation. For example, if you were about to move back from New Jersey into New York and to purchase a primary residence, that would be one situation where that would make good sense. Let me say a couple of things in closing before I turn it over to Barry to talk about real estate. Let me urge you to please read the summary plan description, the document that Kevin has up on the screen that you were each emailed and that is on the Doctors Council website. It's worth reading just so that you can decide what the terms are under which you're undertaking representation. Most of those terms will be repeated to you by the attorney who meets with you, but it's a good place to start. Let me take a moment or two to talk about how you access our services. We're always open. We're available. The pandemic means we're working primarily remotely, but it really hasn't changed much for us. But the place you have to start is not with us, but by contacting the fund office, telling them you wish to be certified for legal representation. You don't have to tell them the nature of the representation. That's confidential. That's up to you. And by the way, everything you say to us is confidential because it's all handled on an attorney-client privilege basis. We're not going to share it with Doctors Council. We're not going to share it with anyone else. We're there for you as your attorney, in the same way as if you retained us privately with no legal services plan. So what you do is you contact the fund office for what's called certification. The fund office will advise our firm, usually Peggy Beckwith, who's the administrative person who handles these, of your certification and the area of law that you're interested in if you tell them. If you don't tell them, Peggy will contact you and you'll tell her if you don't want to tell the fund office what the area of law is. That's your privilege. And we will then call or email you. We will, after we've assigned an attorney, usually if we know what the area of law is, and then you'll have a relationship with that attorney, whether it's the four on this meeting or others, in the same way as if you came to us from our website or from a personal referral or any other. That's all I'm going to say at this point. Let me turn it over to Barry to get into much more substance than what I've covered. Thank you all.
Thank you, Richard. Good evening, everybody. Can everyone hear me? Richard, you hear me?
I can.
Great. So just to dovetail off of Richard's presentation regarding the real estate coverages, as I see some questions were popping up about commercial leasing and commercial purchases. My presentation will solely revolve around the tale of the sale and purchase of residential real estate involving the primary residences, which, as Richard said, are covered under the plan, respectively, if there are two transactions, $575 and $650. The commercial real estate transactions that some of you have asked, and again, I didn't look too much in detail, they just popped up on the screen momentarily, are typically covered under the 2 hours for free general consultation with 50 hours at our reduced rates. Richard, is that accurate? I just don't want to.
Yes, it is, Barry.
Okay, great. So again, I'll be speaking towards the residential primary residence transactions that I handle. We'll start with the sales transactions and sort of from the beginning to the end as to what's involved. And one of the big items that we bring up to our clients, especially our returning clients, is that we should be, or your attorneys, whoever they are, should be involved from the outset of the transaction. And what that means is before you hire your broker, you should be engaging with your attorney. This is typically these transactions, some of the biggest financial transactions that many people will transact in the history of their lives. And so the attorney should be involved in the very beginning. And one of the important reasons for that is that the typical real estate brokerage agreement has a trigger for when the commission is owed. And that trigger is for the broker to bring a ready, willing, and able buyer. And once they do that, the commission is theoretically triggered and the seller would owe the money. We draft our own brokerage agreements that clearly carve that out and say that you, broker, will only get paid when the transaction closes. There's also standard language. I'm sorry?
I don't mean to interrupt. Just let Kevin know when you want slides to be changed.
Okay, this is all on the sales. When I get to the purchases, I'll let him know. This is all under the brokerage agreements that I'm speaking about. There's also another provision in the brokerage agreements, the standard form of brokerage agreements, that talk to if there's dispute over the down payment, that the brokers get a piece of any down payment that a seller might retain under the damages provision. And we, of course, carve that out as well, because typically there'll be a lot of money expended in retaining those down payments. So from the outset, the attorneys will be involved. And if you're working with me, I will also advise you that at that time, you should pull out any old title surveys or permit work, basically your old closing statement, if you have it, from when you purchased. And we would want to take a look at those items to make sure that when you go to sell, we don't identify, or we can identify, any potential pitfalls that we might see on the sale that we could then address either prior to contract or within the contract itself. What we don't want to do is be caught off guard once you enter into a contract to have to deal with any issues that could have been dealt with earlier. So a big part of that is to get your old documents from when you purchased, and certain searches can be done online for things like open permits and any additions. And the open permits are generally if you put an add-on deck or you added a pool to your house, things of that nature, where we would want to make sure that not only did you have a permit to do the work, but that that permit was closed out. Oftentimes what happens is that the homeowner, the seller, doesn't know that those permits have to be closed out, and the contractors will forget to do it. And that process can be somewhat time consuming, and we want to get in front of that process very quickly. One of the other things that you'll hear from your broker is the import of these pre-approval letters. And these pre-approval letters are basically what purchasers will obtain from their lenders to say that they've been pre-approved for a mortgage of X. And what I've been telling all the Doctors Council members that I've had the privilege of representing over the past 21 years, and all of my other clients, is that about 20 years ago, I had the ability to pre-approve both of my cats for $20 million mortgages. So the validity of these pre-approval letters, it's important to note, is very limited. It just says in these pre-approval letters that a purchaser, if they didn't lie on their application and subject to many, many other items, the bank might lend to them. So there's a lack of import that should be put on these pre-approval letters. And once your attorney is engaged, and he would be engaged at that point, or should be engaged at that point, we would let you know that in vetting the various offers you may have on the house, whether they're financing contingent transactions, and we'll dive into those a little bit deeper on the purchase part of my presentation. Those pre-approval letters don't all mean that much. So at this point in the transaction, you'll have had a brokerage agreement in place. I will have, let's just say that I am your attorney. I will have had all of your old legal documents from your closing, and we will have vetted all the buyers, and you'll have made a decision who to go with. So at that point, the broker will promulgate or draft the deal sheet, send it out to the attorneys, and both for the buyers and the sellers. And the seller's attorney, me in this case, would be drafting the contracts. The contract drafting would then go back and forth for negotiation, and at some point be signed. And at that point, a deposit would be made by the purchasers, put into our escrow account to be held as the down payment, and we would move towards closing. In the instance of a co-op sale, where you're selling a co-op, one of the things we want to get in front of very quickly in the beginning of this process, before the deal sheet is promulgated, is obtaining your old stock and lease. So if you had no lender, or if you paid off your loan, you would be in possession of the stock certificate and the proprietary lease. Those documents are an integral part to closing. You would absolutely need those to close. If they're lost, there are ways to get over the issue of them being lost, but they're important to have. And if there's an existing loan, the process of getting those documents into the hands of the lender's attorney is, again, a time-consuming process. So all things we want to be thinking about before we go to contract. So assuming we've done all those things, we're now in contract and we're moving towards closing, everything goes well. As a seller, you face some large closing costs in the state of New York. The major closing costs, the biggest one, is typically the real estate brokers. Real estate broker fees range anywhere from 4 to 6% on a typical basis. They could be lower than that depending on the deal that you strike with the broker. For instance, if the broker that you hired to sell the apartment or the house is the only broker on the deal, sometimes we negotiate from a 6% commission to a 4% commission in that instance. And again, that would all be afforded for way back in the beginning of the transaction when we're drafting our brokerage agreement. So another big difference in our brokerage agreement from a standard brokerage agreement is that we address all of these different circumstances. So for instance, if you as a seller bring the buyer, you shouldn't, in our view, have to pay the broker their full commission. So we would say that they get 50% of the commission. But typically on a straightforward transaction where there are two brokers, one on the sell side, one on the buy side, the commissions range anywhere from 4 to 6%. More standard is 5 to 6%. The standard being 6, we try to negotiate it for less. So you have the real estate brokerage fee, and then in the state of New York, we have transfer taxes. In the city of New York, there's an added transfer tax. The state of New York has increased their transfer tax sliding scale. So depending on the sale amount, it could range anywhere from 0.4 to 0.65%. And on the transfer taxes for the city, you're looking at typically 1.425%. So an aggregate of approximately 2%. In the instance of a condominium sale or a co-op sale, we also have to look at any transfer fees that those buildings may have, commonly known as a flip tax. And those can range anywhere from 1% to 5%, or are sometimes calculated on the basis of shares that you may own in the co-op. What I typically advise my clients is that 10% is sort of the number you need to beat to get over the closing costs. So whatever you purchase your house for, you've got the closing costs that were associated with that, plus about 10% closing costs on the purchase. And once we get to the closing, those closing costs will be due. Typically, they're paid either out of the down payment or as a purchaser payment towards the balance that the purchasers owe you as the seller. One of the nuances that has crept up on us, not so much crept up, but sort of surprised us in the beginning of COVID back in a year ago, was how do we handle these closings? Because again, no one wants to sit around the table and be concerned about contracting COVID or giving people COVID. And so what we've come up with is this notion of a remote closing, which is very typical in the commercial world, but was rarely, if ever, used in the residential context. And so the remote closing is basically a closing where very few parties will be at the table at the same time. So on the day of closing, typically the sellers will have pre-signed all of their documents and either given them to their title company, to the title company, or in the context of a co-op or a co-op, given them to the managing agent. We'll get to what the remote closings look like on the purchase side in a minute. They're a little bit more detailed, but for a sale, typically we would have you as the seller pre-sign all of your documents, and someone would act as the escrow agent of those documents, meaning they hold on to those documents until we authorize their release. That release would occur upon payment of the purchase price and any other triggers that might occur. So that's sort of the broad strokes of a sale, from the brokerage agreement through the remote closings. On the purchase side, the tail sort of begins with you identifying a home, obviously. And then what typically occurs right after you identifying a home is the engineer inspection. And again, that's about the time that you want to get your attorneys involved. Once you've identified a property and you want to move forward, no later than that is the time to engage the attorneys, engage me, engage the firm. You would then have an engineer inspection done. The engineer would not only look for termites, which is sort of the standard part of the engineer inspection, but also look at the entire building, or excuse me, the entire home that you're buying for any defects that he may be able to identify. We recommend on the apartment purchases, condo or co-op, that you also get an engineer inspection for those as well. And the reason for that is twofold. One is to make sure things like the appliances, the plumbing, the heating, electric within the apartment are operable and are in working condition. But also, typically the engineer is given access certainly to the outside facade of the building, sometimes to the roof, sometimes to the basement. And that's important because the engineer can identify in these buildings potential defects, whether it be a roof replacement that's needed, facade work that's needed. And then we can extrapolate from that how the building plans on paying for that. And that would be one of our due diligence questions. And that sort of flows into our next topic. Before I get there, one of the other things on the purchase end that a purchaser should be looking at is to be contacting the homeowner's insurance company to make sure, at least in the case of a house, sometimes in the case of an apartment, that no flood insurance is required. Homeowners insurance, the rates are based in part on the value. Flood insurance, you want to make sure that there's not going to be at the last minute an added cost. So that's part of that sort of original due diligence. As far as our due diligence as your attorneys, limited on a house inspection to really reviewing the engineer. If there's wetlands or other Department of Conservation issues that we need to look at, we would look at those. But on the condo and co-op side, we review the minutes, the offering plan, and do some corporate searches for open permits online as well. All this before you sign a contract. And again, just to reiterate what Richard had said earlier, these are, by the way, the same services that we provide to other clients who are not part of the legal services plan at that much higher rate. These are the exact same services. So it's not as if you're getting less out of us under the plan. To the contrary, you're getting the exact same services, which in part involve the due diligence on the condos and co-ops, which is very forensic almost in terms of what we look at. We also look at the financials of the building as well to see what we can garner from those. And we recommend that you send them on to your accountants for review as well. So after all the due diligence is done, assuming everything looks good, the contracts are issued by the seller's attorney. We review them, we negotiate them. And once they are in form that is acceptable to everyone, a down payment would be put down. Typically, that down payment is in the amount of 10%. So you should be prepared for that 10% down payment at the outset. Certainly before that, if you require that you finance a part of the transaction, you should be in conversations with your lenders to be sure what amount you can borrow, because it's not always certain that you'll be able to get what's known as a financing contingency in the contract, meaning if you don't get the loan, you can get your money back and get out of the deal. So always a good idea to be speaking to your lender, who will issue what's known as a disclosure document evidencing some of the closing costs. As part of our due diligence, we'll go over what we estimate the closing costs to be. We're usually much closer to the actual amount than the lenders are. Those closing costs that we're speaking about now, the major closing costs are your mortgage recording tax, which depending if it's Nassau, Suffolk, Westchester, or New York, range from 1% to 2% for the mortgage recording tax. There's title insurance, and there's your mansion tax if you're purchasing over $1 million. And that again is on a sliding scale. It's 1%. It starts at 1% for properties between 1 and 2 million. There are also your lender's fees, which involve escrows, the first payment of your loan, lender attorney's fees, and again, the possibility of a flip tax if it's a condo or a co-op. It's not always the seller that pays the flip tax, depending on the building. So getting back to the financing and funding contingency aspect of this, when you're making your offer, so going back to sort of the beginning of the tale, when you're making your offer, if you require financing and you cannot close without the financing, one of the things you want to be sure you do in communicating with your broker your offer is making sure that they understand you need what's known as a financing contingency. And that contingency means that you need to borrow X amount of dollars. And if a bank says no to you, then you can get your money back out of the transaction. It's a contingency built in to the contract. And we add, as part of our comments to the contract, what's known as a funding contingency, which means that even after the financing contingency is met, if the bank backs out for any reason, and sometimes those reasons are limited, you can get out of the transaction as well. So fast forward, we're in contract, the loan goes okay, you're now ready to close. You'll do a walkthrough inspection of the property, making sure everything is in its as-is condition. And then we go to closing. What does the remote closing look like for a buyer? It's a little different. We don't attend the closing typically. We attend it remotely. So what'll happen typically is that you as the purchaser will be in the event of a co-op in the managing agent's office, or in the event of a condo or a house, you would be in either the lender's attorney's office if you're borrowing, or the title company's office. And I would FaceTime with you, having read through all the documents that would be in front of you, and walk you through all of the transactional documents, so that other than my physical presence, the legal aspect of it, you're covered. I'll be watching all of the documents you sign. In the case of a title closer being there on a condo or a house, they're on sort of our side. They're people we hire. So there's a second set of eyes. They'll be present at the closing. And you will go through the process of signing all the documents and closing at a remote location, meaning the location of either the lender's attorneys, the title closer's office, or in some cases, the seller's attorney's office if they're attending. But as it stands lately, what we're finding is that the remote closings typically take place in the sorry, I just had an interruption, in the office of the lender's attorneys. And at that point, you bring the balance of your funds. We'll go through all the closing costs beforehand, and we close the transaction. And that's sort of the tail of the tape on the purchase side. So with that, I'll turn it back over to Richard, and I'll take a look for any questions that came up on the during the speech that I just gave, and maybe we'll turn back to them at the end.
Thank you, Barry. Our next speaker is Richard Kay, who'll be talking about trusts and estates. Richard?
Yes, good evening, everyone. Barry, that was a brilliant presentation. I learned more. I thought I knew everything, but now I know that much more.
Thank you. Thank you. I appreciate that.
The PowerPoints were displayed on the screen. I'm going to deviate slightly from them. I'll try to cover all the points that are specified therein, but I will not follow the sequence exactly as it's stated. As Richard said, I'm Richard Kay. I'm a member of the Trust and Estates Specialty Group at Prior Cashman. We have 8 talented attorneys who are particularly skilled in all aspects of estate matters generally. Once a Doctors' Council participant wishes to embark on estate planning in a general sense, that member is certified by the Doctors' Council and then is assigned a Prior Cashman attorney to work with that member on the project. That attorney will be the primary contact at Prior Cashman and will be responsible for all aspects of the estate plan. In the simplest possible terms, estate planning can be described as an effort to organize your financial matters during your life so that your heirs are not left with a mess once you are gone. In my years of practice, I have encountered many such messes, but I don't want to burden you with the details as they are not pleasant. That should elicit a bit of humor from some of the viewers here. The first step in the process, ideally, is to have the attorney meet with the client and understand his or her special needs and objectives. Unfortunately, in this pandemic environment, a personal meeting is often challenging and communication is required by phone or email under the circumstances. Often the meeting or communication includes both spouses in a relationship or the significant other if that is appropriate. It is critical that the attorney have an understanding of the assets of the client, including as much detail as possible. By that, I do not mean a list of all the securities that a client has in a brokerage account, but more generally, the value of an account, information about a residence, life insurance, pension plans, valuable personal property, and any other assets that the client owns. It is critical that the attorney have as much information as possible about the form of ownership as well. By that, I mean whether the assets are jointly or individually owned, or who, if anyone, is the beneficiary. For example, the life insurance policy or pension plan. Our goal is to make this, Prior Cashman's goal is to make this experience as user-friendly as possible. Unlike many other legal representations, this should be a pleasant and not intimidating experience. Over the years, I think as I stated previously when Richard introduced me, I've interacted with people from all over the world, and it's been a great pleasure to see how the United States has become the melting pot for people from everywhere and anywhere. Once the asset list is presented, the next step that the attorney has to determine is who will inherit the estate on the death of the client. It is the attorney's responsibility, in my view, to explain the options to the client, and the client will then guide the attorney with the specifics. In other words, where do the assets ultimately go? I think you can figure that out on your own. In a spousal situation, obviously, it's likely the spouse, children. If the person is a single person, then it becomes much more complicated. Whether it's cousins, friends, relatives, charities, you can figure all that out independently. In my PowerPoint, I referred to the question of what is a will. In the simplest terms, the will is a document that determines what happens to one's assets on death. It is a misnomer to characterize a will as the last will and testament. It is the current will and testament, and only becomes the last one, obviously, on the death of the testator, the person who signs the will. In many cases, too many cases, from my experience, people end up signing 20, 30 wills during their lifetimes because of their changing relationships, often their changing assets, and other circumstances that come to play in that decision. Notwithstanding that, it is really critical as we view it to have a will, as the laws of the jurisdiction determine what happens to the assets if the client dies without a will. And some of those laws are somewhat confiscatory, if you will. I'm not going to go into details other than just to state that it's somewhat surprising what New York laws would dictate if a person died without a will. In addition to the will, there are many other methods of disposing of assets. I refer to joint ownership, beneficiary designations, and forms of trusts, there are numerous kinds of trusts that we could talk about. That's an area of itself. Would require an inordinate period of time to talk about the various kinds of trusts that we could create. In many cases, there are trusts created under the wills. I also should add, I think it's been made clear, we do not count the hours expended on this estate planning process. We have to spend as much time, and we're prepared to spend as much time as the client needs and wants to complete the project. And if it turns out to be significantly more hours than we would normally do, the fee remains the same. The amount of time, again, is not a function of the amount of hours expended. In addition to a will, the attorney is responsible for preparing a trove of other documents. I refer specifically to a power of attorney, a healthcare proxy, a living will, a HIP authorization form. These are really important, and we emphasize that the clients think about those decisions in advance, and we will prepare the documents and arrange for their signatures in the appropriate way. One of the other points that we have focused on is the area of estate administration. It's a very complicated area. And Prior Cashman is fully prepared to assist doctors' councils family or relatives of certain categories in the estate administration area. We're available to assist anybody with all kinds of issues facing a family. When a member or relative dies, that is a challenge in itself. But suffice it to say that it's often a time-consuming and emotional period for a family. And I think we're really good at hand-holding, which is very critical and necessary at that point. We have considerable expertise in everything relating to estate administration and working with the survivors in any way possible subsequent to the time of death until the assets are finally distributed to the beneficiaries or heirs of the estate, whoever they might be. I could go on endlessly about the trust issue. There have been several questions raised about trusts and how they're created, but it's a topic of itself. And I'm prepared to answer any questions subsequent about in that particular issue area, because trusts are so complicated. There are lifetime trusts, there are testamentary trusts, and I'm prepared to discuss individually with anybody who has a specific question about a trust. But as I say, it's a subject of its own. In the interim, we've received several questions concerning estate planning and estate administration. One of the particular interests relates to the estate tax rates. Let me tell you what the current situation is, and I can't predict where it might go. The current federal estate tax exemption is slightly less than $12 million per person, and double that for a couple. It's a complicated calculation, but leave it at that if a couple dies under the current laws, the exemption, if it's properly presented, would be roughly $24 million. The New York exemption is slightly less than $6 million, but is not structured to qualify for this double benefit as the federal exemption is. We've been asked what my prediction is about where the estate tax rates are going. I have no idea. Senator Sanders has recently proposed changes that are onerous at best. At worst, I can't even say that. It's not likely to pass, but it's likely that there will be some changes in effect from time to time, possibly reducing. The $12 million exemption is a very generous one. It's written in the law so that it would terminate in 2025 under the current law, but it's possible that it will be modified prior to that time. There was another question about whether we can handle a New Jersey matter. We do have the capability with attorneys who can assist us with New Jersey estate planning matters. Typically, if it's a New Jersey estate administration probate, we would recommend that a New Jersey attorney be hired for that particular purpose. My final comment again is about trusts. I don't want to belabor the point, but they're very complicated. They're very time consuming. There are numerous options that are available. And again, I'm happy to speak to anyone who has some specific questions about it. But again, it's a subject that requires a huge amount of time. We have the expertise, and you should know that many of the wills that we draft for clients include trusts within the document themselves. Again, I'm free to speak to anyone or answer any questions that might arise, and it's a pleasure to speaking with all of you.
Richard Bethel, for the sake of, thanks, Richard K. Richard Bethel, for the sake of time, maybe we'll go on to the next couple of presentations, then we'll deal with questions at the end.
That makes a lot of sense, Kevin. The next speaker will be Elizabeth Warner on family law.
Hi. Could you move the PowerPoint one over, please? As I mentioned earlier, our practice group does all manner of family law matters, whether or not you're married or unmarried. And we have a group of 9 attorneys, all of whom are very capable of representing you in your matter. Today, we're going to focus on divorces because that's typically why doctors counsel clients come to our doorstep. As Richard mentioned earlier, There is a flat fee for really just filing paperwork and going through the appropriate channels to obtain a divorce if you have your issues worked out before you come to lawyers. However, most of the time there are the devil's in the details, and you do need to have us negotiate some things that you might not have considered when you were just working out things with your spouse. And for that purpose, there's, a schedule of rates. So just to jump in here, the main issues that have to be discussed and resolved in a divorce are child custody, the division of assets, and spousal support and child support. And just to go to kids first, because kids are most important, if you could go to the next slide. Custody in New York, it applies to children under the age of 18. This age limit applies even if you have a special needs child who will never truly emancipate and will always be dependent on you. The child custody laws of New York deal with children under the age of 18. Over the age of 18, you get into guardianship law. So, with respect to the domestic relations law for children under age 18, there are really two areas that need to be covered, and that's decision-making and parenting time. And with decision-making, it's really like an employee handbook, we like to say, because it's something, even if you're very amicable when it comes to parenting matters with your spouse and you don't anticipate any issues, you want to have a rule book to turn to if there are ever any issues in the future that pop up. And a lot of details can get worked out in a custody agreement that aren't really at the forefront of people's minds when they have a lot of other stuff going on in their divorce. But just to run through an example of what a custody agreement would include, obviously agreements on how decisions are made. And that includes medical decisions, education decisions, religion decisions, extracurricular activity decisions. Any decision that concerns the health and welfare of your child can be encompassed in a custody agreement. Most parents can engage in a joint decision-making process. If you do not fall into that category, you certainly will be in a much more litigious landscape, just due to all the unforeseen issues that can arise when one parent has the final say. That has to get hammered out. In a dispute resolution agreement, we will try to put a process in place for making decisions, and that would be timeframes for notices to be given to the other parent, professionals to speak to before you can go to court, who can be the tiebreaker in those decisions, and all of the factors that have to get included. Other things that come up in a custody agreement are parameters around travel with the child, communication with each other around things around the child, making appointments, doctor appointments, counselor appointments, things like that, scheduling things on other people's time. What else can we talk about? Emergencies, who holds the passport, who holds social security cards. All these details are things that you might not think are a big deal and that you will and your spouse will be able to work out, but then down the road somebody makes an appointment and they weren't authorized to do that, or you didn't agree with the medical procedure that they were signed up for, and you need to have a handbook to look to for how that should play out to reach a resolution. Parenting time, again, it's a schedule for sharing regular time, holidays, and makeup time, and that can sometimes seem like common sense. You get this weekend, I get next weekend, and we'll figure out the rest. But a schedule is important to put in place so that if there is ever a conflict, you have a default rule to turn to for what controls. So if you had Christmas this year, but you wanted to have Christmas next year because some big family reunion was happening and the other party didn't agree, then the default is the agreement. So those are important things to have in place when you have children and you're getting a divorce. So the next slide, please. So equitable distribution of assets. In New York, we distribute assets equitably, not equally, as the saying goes. However, the longer your marriage is and the more intertwinedness that you have, the more likely you will be dividing your assets equally. There are 14 factors that are considered by a court under the domestic relations law in distributing assets. And that includes, you know, the income and money you came into the marriage with, your health, your age, the duration of your marriage, whether or not you had children, your earning capacity, a whole host of factors that go into it. So if you do not want to divide your assets 50-50, that is certainly something that you can agree on. Or some people divide their assets with, I'll just keep what's in my name and you keep what's in your name. And then that is a way to equalize the assets without having to divide each one item by item. So first, you classify what's marital and separate. Separate property in New York is anything that you had before the marriage, any gifts you receive from third parties through inheritance, and the like. Marital property is typically earned income that is retained and saved and has grown. And that includes not only what's in a joint account, but also appreciation on what could be a separate property asset if you actively managed it and grew that asset during your marriage. Fortunately for doctors, doctor's license used to be considered a marital asset in New York. It is no longer treated as such. So special considerations for retirement assets. I know the Doctors Council has always had pension questions. Our clients always have a lot of pension questions. There are two things that you can do with a pension in a divorce. Number one is have it valued. And then the marital portion is valued, and you can trade off your pension for an in-kind other asset. Or you can divide your pension, which literally means the income stream gets split at the time of retirement. Now, the marital portion of a pension is a fraction, the numerator of which is the number of years you participated in the pension during your marriage. The denominator is the total number of years of your marriage. And then you take that fraction, you multiply it by the value of the pension, and then you multiply that by 50% or whatever your spouse's share would be. And that is how that gets distributed. It does get, if the pension itself is divided, you will need a separate court order to do that. It's called a qualified domestic relations order. Typically an actuary will put that together, and you just have to have it signed along with the judgment of the divorce by the court. Next slide, please. So the last sphere that gets dealt with in a divorce is support. So spousal support and child support under New York law are both pursuant to a formula. However, it's a formula asterisk. The spousal support formula, it goes up to $192,000 of income, and you plug in the formula and it spits out a number. But then a court could deviate from that based on a whole host of factors, including the lifestyle you've led, etc. One thing to note is when you do get a divorce, that your spouse will be terminated or kicked off your employer provided health insurance and vice versa. So certainly your spouse needs to be aware of that and know that they have to obtain their own policy once a judgment of divorce is entered. And we often negotiate provisions for the continued payment of health insurance for a period of time. Child support in New York is also pursuant to formula up to $154,000 of income, but then it can also go above that cap of $154,000 based on a whole host of factors. In addition to base child support that's paid to a parent, there are, quote, add-on expenses, which are expenses that are typically paid to third parties directly for education, medical, childcare, extracurriculars, and camp. And those are split on a pro rata basis. So if I make $75,000 and you make $75,000, then we'll split the add-ons 50-50. But that share changes depending on the disparity in your incomes. Both child support and spousal support can be secured by life insurance. In other words, if the payor of the support dies, there is a life insurance policy that will be in place to pay out whatever outstanding obligations were still owing at the time of the payor's death. Certainly with children, you can appreciate that they might have a long span to be receiving support. So they need to be secure that they will be financially provided for if something were to happen to the payor. And those are the main areas that get addressed in a divorce. And then once your divorce is all agreed upon, then it is set forth in an agreement. And then the agreement is submitted along with several forms to the court, and you request a judgment of divorce that simply incorporates the terms of your settlement agreement. And then you have to wait for the judgment to be entered, at which time you are officially legally divorced. So that's about all I have about that.
Thank you, Liz. Now, our last speaker is Steve Rabinowitz. It's, as the heading says, Steve is talking about, among other things, protecting your license.
Okay. Hello, everyone. So I'm going last, and there's a reason for that. We want you to be successful enough that you need to come to us to help you buy a home. We want you to be happy enough that you never need a divorce. We want you to be smart enough that you come to us and make sure you take care of your will and your estate planning. And we want you to be fortunate enough that you never need our services when it comes to protecting your license. But if you do, we're very much here for you to help you with that. And let me talk very briefly about the Office of Professional Medical Conduct. And I think we can skip this slide and just go straight to the next one. And first, just to tell you what that is. It's very simply a state agency that investigates and prosecutes misconduct of doctors and nurses. And it's staffed by professional investigators who are not medical people, as well as doctors and nurses who do obviously understand medical issues. And it will conduct investigations. Those investigations begin on an informal basis, so you have an opportunity to meet with them and talk to them about whatever issue has arisen. And if a lot of times the cases are resolved at that initial stage, and if they're not resolved at that initial stage, the matter can go to a hearing, which is essentially a full-blown administrative trial. It's like going to court. There's no jury, but you do have a panel that's comprised of doctors and lay people who will decide what the facts are and ultimately render a decision about what should happen with your license. And in terms of what can happen to your license, there's a whole range of sanctions. It can be everything from as mild as a reprimand or a requirement that you go for certain retraining, up to a suspension of your license for a period of time or a revocation. Revocations are rare in our experience, and they really require some truly egregious conduct. And most of the time, we're able to resolve matters without serious consequences. So what exactly does it mean to talk about professional misconduct? What is that? I think most doctors are familiar with the idea of what does it mean to be involved in medical malpractice, but professional misconduct is a slightly different animal. The statute has a 50-item list, and it ranges from the obvious, things that are essentially like medical malpractice, gross incompetence. It can be as simple as a single act of gross negligence. And when I use a term like gross negligence, I mean something well beyond mere malpractice. It gets to the point where the conduct pretty much shocks the conscience. It's that bad. Or it could be multiple acts of ordinary negligence, ordinary malpractice. But the 50-item list contains things that are not so obvious. The statute says it's a violation of professional misconduct if you use advertising that contains testimonials. You can be charged by the OPMC if you fail to wear an ID badge when you're working in a hospital. Now, those cases are, of course, rare, but it could cover a whole range of different things. And if you'd like, if there's an interest, we can supply the list of the 50 different things to Doctors' Council so you have it handy. But for the most part, it's things that you would know right away that you're running a risk of coming afoul of the OPMC. It's some act of gross incompetence, gross negligence, something that would really get the hospital's attention where you're working, and that could be passed along. There's also a catch-all. That's why it says it ranges to just about anything. And that could be that the conduct and practice of medicine that evidences moral unfitness. And moral unfitness is obviously a very elastic term, so it could cover any number of things. So it's possible that if something has gone wrong at the hospital, for example, some terrible run-in with involving maybe allegations of discrimination or sexual harassment, although those are their own separate category on the 50-item list. But moral unfitness can cover a broad range. I will tell you that it does not cover moral unfitness outside of the practice of medicine. We recently had a case where someone was accused of harassing a woman, but she was never his patient. And so we were able to get OPMC to dismiss that case altogether and stop their investigation. So the question is, if you are so unfortunate to find yourself in the crosshairs of OPMC, what do you do? And that brings us to our next slide. First thing, do not speak to OPMC. They are investigators. They are the enemy. You do not want to speak to them other than just to make arrangements to tell them you're going to be retaining a lawyer and to not answer any of their questions. You don't want to do that. You don't want to speak to anyone about the case. You should not, the first thing when OPMC looms its ugly head is there's a tendency to panic and to want to start talking to people at the hospital and getting advice. That shouldn't be the first thing you do. You want to contact us immediately. You want to get our advice. You want us to be the ones dealing with OPMC, arranging scheduling, finding out as much as we can about what the nature of the allegations are. And then we will advise you on how to proceed with those allegations. You'll need to preserve all the records of your interactions with the patient. But remember to keep the HIPAA regulations in mind. Even when it comes to sending stuff to us, make sure you clear with your hospital whatever you're going to be sending us by the way of medical records. It's just because we're your lawyers and just because everything between us is confidential doesn't mean you can simply send us the medical records. We have to do that following HIPAA protocols, and it's always a good idea to clear that with your hospital, which will almost invariably be aware of the allegations. And if they're not, then we'll help you navigate HIPAA directly. The most important thing is don't panic. Most cases resolve without the stress and the expense of a hearing, and most were able to resolve them without dire consequences. So since we're short on time, and I know we want to get to some of your questions, let me just touch briefly on the next slide of some of the other things that are similar to OPMC that you might encounter along the way. And the same rules apply. Don't engage in discussions with them. Get us as your lawyer involved right away before you say anything to any of these agencies. Involve us, preserve the record, don't talk to anyone. So one is the Department of Investigation, also sometimes referred to as the Inspector General's Office. HHC has its own specific Inspector General and DOI staff. They typically investigate allegations of fraud, such as a recent case involved allegations that doctors were supposedly getting phony CPR certifications. We successfully defended against that allegation, which would turn out not to be true. They also will investigate institutional failure. Those of you at Kings County may recall the incident involving Esmond Green, a psychiatric patient who died in the waiting area and was no one realized she had passed away for several hours. And there was a full-blown investigation about that. We stepped in, and again, none of the doctors suffered any consequences. Another agency that might get involved, particularly if you work in an institutional setting, is something that's usually just simply referred to as the Justice Center, but it stands for the Justice Center for the Protection of People with Special Needs. And it generally relates to investigations of allegations of serious neglect or abuse at institutions. It can sometimes look at hospitals and conduct there. We recently had an investigation involving a patient who came to the ER, was assessed, and then later went to another hospital where that patient committed suicide. Again, it would seem at this point in the investigation that that's been resolved in favor of the Doctors' Council doctor. The district attorney's office, at times, or the police get involved in investigations. Usually that's where there's fraud. Occasionally, though, that's where there's allegations of some form of criminal neglect, but that's exceedingly rare. But of course, if the police contact you about anything having to do with a patient or the district attorney's office, do not talk to them. Tell them you want a lawyer and that you're going to be hiring one, and then get in contact with us. Two other things came up in the questions. One was whether our firm will help you in an EEO investigation. We will. We have a lot of expertise there, and we have done so for doctors. And that's covered under the general plan, where you get the 2 free hours of consultation plus 50 at the reduced 200 an hour rate. And the other question I noticed before the call was, what about IRS audits? And again, we have a very well-credentialed tax department that can help you with things like that. But since I know time is short, let's turn it over to everyone again, because I know there were a lot of questions popping up on the screen as we went along.
Thank you, Steve, and everybody from prior. We appreciate those presentations. I'm going to read through some questions doctors put in through the text, and also if we have time, some were submitted by email. I'm going to flow them between myself and Richard Bethel, and Richard, as you deem appropriate, bounce them off of your colleagues if need be. So in no particular order other than how they were chronologically submitted. Can doctors who live outside of New York City benefit from these services? Richard, correct me if I'm wrong, that a doctor who's outside of New York either falls under the out-of-state benefit, which has a reimbursement of $600 for wills or real estate transactions, or, and Dan Donnelly can help me out, before the beginning of the relevant plan year, they can notify the plan office that they want to opt into the New York State benefits. Is that correct?
That is correct.
So again, if a doctor wants to opt into the New York State benefits, the welfare fund plan year is July 1st. The benefit is January 1st. If you contact our office and say that you want to opt into New York State benefits, then please do so. Next question. What are the average expenses associated with a single real estate transaction, first home purchase?
Sounds like a question for Barry.
I'm happy to answer. So typically on a residential real estate closing, you're only looking at a few Federal Express packages. On the occasion where we used to have to travel, there may be travel expenses if we had to go out to Westchester. But being that I am, so typically those are the expenses. The expenses don't typically add up to the amount of the retainer that we take, and in which case we refund to the member any overage that we took in the outset of the retainer. So typically, if I had to put a number on it, $50, $60 in FedExes, and limited on the travel fees.
Thank you. Next question. How about commercial lease for medical office? I'm going to interpret that. Does that mean that covered? Richard Bethel, will that fall through real estate or through the general
That
consultation?
would fall under real estate, but not under the real estate plan, under the legal services plan, which is limited to your primary residence. That's something you would come in, you'd be certified to us. Somebody in our commercial real estate department would handle it. And it would be, the first 2 hours would be without charge, and then would be that reduced $200 per hour charge thereafter.
For the 50 hours. So that would fall under the general consultation, 2 hours free, then 50 hours at the 200. Thank you. Next question. First home, primary residence in Manhattan condo, purchase. How to retain your expertise and cost. On the first instance, Richard Bethel, contact our office and we'll get you certified to access prior cashman. Second part of the question, the cost. Richard, would that be the $575 through the real estate?
Yes, it would, as long as it's a primary residence.
That's the answer to those questions. Next question, for investment property, buy or sale, what would be the cost?
For an investment property, it would be based on that general consultation charge. So again, 2 hours without charge and 50 hours at $200 an hour.
For an irrevocable trust setup, is there a set fee or is it based on estate value?
That I think, again, and Richard, please correct me if I'm wrong, I believe that would be under the general consultation charge of 2 hours free and 50 hours at 200. Richard, is that correct?
I don't think that's accurate, Richard. There is an additional charge. I believe it's $300 beyond the general estate planning fee of for preparation of a trust. We can check further on that, but that is my belief.
Okay.
In the case of complex estate planning documents other than the will or codicil, power of attorney, et cetera, such as insurance trust or trust documents related to estate planning, this will be prepared for an additional charge of $300 per document. Is that what you're referring to, Richard K?
That is correct.
Okay, thank you. Next question. Does the plan cover family members? For example, real estate transaction for daughter of member, both member and her daughter are on the deed contract.
As long as it's the primary residence of the member, the answer is yes. If it's not the member's primary residence, it would not be covered under that fixed fee.
The concept there being primary residence. Got you.
It is.
Next question. For billable hours that may be incurred, since you set the hours spent, is it an honor system?
I'm not sure what that question means, Kevin.
I'm going to stretch it out further. How do you track the hours and how do you convey that to the member?
Every attorney in the firm for every client keeps track of his or her hours every day. In fact, during the day. And whenever we render a bill, the bill, if it is by the hour, if it's not for a fixed fee, it will set forth precisely what was done for that time with the attorney's initials and a brief description of whatever work was performed.
So it'll be transparent and share with the member. Got you.
Kevin, specifically with reference to estate planning, there is never an additional fee if it's a basic estate plan that we're engaged for. We do retain the hourly rate, retain the hours, keep track of the hours, but there is never an additional fee unless it becomes preparation of an insurance trust or some other document that's unrelated to the original wills.
Thank you. How does the transaction differ if no broker is involved?
So the main difference, Richard, I'm happy to just field this. The main difference is a difference in the costs. In other words, there's no brokerage fee. It's more difficult when you're on the either side, the purchase or sale, when there's no broker operating as the as a broker would to negotiate the terms of the deal. So it's oftentimes the case where purchasers will engage a broker at a limited cost of their own just to help them through, for instance, the condo or co-op board package. So it does become a little bit more laborious for both the attorneys and for the purchasers and sellers when there's no broker. But again, because the primary residence sales are fixed rates under the plan, the additional legal time is not charged to the member. So it's a function of us as the lawyers having to do a little bit more work because there's no deal sheet that would be promulgated.
Thank you. About how much approximately would a will, living will, healthcare proxy cost?
There's a flat fee, Kevin. I believe it's $450 for a single person, $800 for a couple.
And pursuant to page 4, you're correct. Thank you.
Thank you for clarification.
What are your thoughts on the home title insurance advertised recently for events someone takes over your title and borrows against the house?
Yeah, you'll forgive me, Kevin. I am not at all versed in that. I saw that question come up earlier on the screen. I don't know what that is, so I can't reply to it.
So let me suggest, the doctor who asked that question, if you get a hold of me tomorrow at the office, we'll try to make a conduit and drill deeper in that. And thank you for asking the question.
Yeah.
Do you cover special needs trust?
Yes, we
Generally,
do.
no. We do have the capability of doing that. Typically, we refer we don't have a special expertise in that area. They're not that complicated. The special needs trust is fairly basic. As far as disability benefits are concerned, this is not something that Prior Cashman does. We refer people to elder law attorneys or disability attorneys who specialize in guiding the clients with respect to the governmental benefits. That is not something we do, but we do prepare special needs trusts. They're often incorporated in the basic will. And if they are in the will, a special needs trust is often included, as I say, in the will. And if that is the case, there is no additional charge for preparation of that will.
Thank you.
It's a great benefit to the members.
I'm going to add to the question here. If need be, would the attorney go to court?
Oh, sure. I mean, we're lawyers. We have a very large litigation department. We litigate all the time.
Yes. There's a question, will a recording of the presentation be available? Yes, we are recording it and planning on emailing it out to people who RSVP'd. I work for HHC. If there is a malpractice suit, I understand they provide legal representation. Part 2 of that question, since HHC represents their interest and not yours, is it prudent to get my own attorney?
So I'll answer that by saying you have to be careful not to conflate malpractice with OPMC proceeding, which is an administrative proceeding regarding your license. We don't do malpractice defense work. And so we're not really in a position to advise you about that, or to advise you whether you should have separate counsel, even when HHC is representing you in a malpractice action.
Got you. Can you be retained for the lawsuit with NYSERS, New York City Employment Retirement System pension plan?
Technically, not under the legal services plan, because that is obviously something arising out of your employment.
Are private practice issues outside of the Department of Health and Mental Health work applicable? If so, if that private practice issue is outside of New York City but live in New York City, does the coverage have to be expanded?
I'm not sure I understand the question.
let me try to amend it this way. I apologize to the doctor if I'm interpreting it the wrong way. If the doctor's a member of ours, but has an issue not related to where he or she works, but let's say in private employment, could they go to prior Cashman to utilize services? Richard Bethel, tell me if I'm wrong. If it doesn't fall under one of the predetermined areas, then it would fall under the first 2 hours free and then the 50 hours at the reduced rate of 200 per hour.
That's correct. That's correct, Kevin.
Okay, thank you. There's a question in all caps. Barry Landsman, can you help selling inherited residential real estate?
So yes, the answer is we can handle non-primary residence, which is what this would fall under, but that falls under the general consultation, which is the 2 hours with the 50 hours at the reduced rate.
Thank you. How do we set up a consultation to discuss the different types of trusts to be able to do some estate planning? Please contact info@doctorscouncil.org or Dan Donlin, or call 212-532-7690. Or if you registered for this presentation, then just reply back again saying that you want to access the services, and someone will gladly assist you along those lines. For eventual license issues, do we qualify under the plan if we live in New Jersey or Connecticut but practice in New York?
For eventual license.
The word eventual, if the doctor has a license issue, they live in Jersey or Connecticut, but they practice in New York.
The general rule on the plan would be that if they're not enrolled in the in-state plan, they would not be covered. But I don't recall an instance when we have not found a way to provide representation one way or another.
Yeah, if the doctor, correct me if I'm wrong, if the doctor's license is in jeopardy, we have the provision there for the license representation that Steve Rabinowitz articulated. And again, doctor, if you need assistance, you can contact us or Dan Donlin if you want to switch to the in-state plan before the beginning of the plan year. Next question, what happens after the first 50 hours?
After the first 50 hours, you have the option of retaining other counsel, of course, or continuing with us at what is a predetermined 20% discount from our regular rates.
Thank you. Will you represent for any law trouble such as assault, eviction, or eviction process?
Yes. We have criminal defense expertise and also some really top-rate landlord-tenant expertise, so we can represent on both of those things. So they fall under the general plan.
Got you. There's another
What
question.
Steve not say before, but is relevant, is he started his illustrious career at the Manhattan DA's office. So he's very familiar with those criminal issues.
Thank you.
So I will say they've rarely come up with doctors.
True.
Thank you. There's another question about recording. Yes, it will be available, and yes, how can you access it? We will email it out to everybody who RSVP'd for this presentation, whether they showed up or not. If you're here, you'll get it. Next question, how does one find out if it is appropriate to have a premarital agreement based on their income?
One would, again, contact the fund office, be certified, be assigned a family law attorney, and that attorney will review with you all the considerations and help you to make a decision.
Understood. Thank you. There were some questions which the doctors submitted. Those are the questions now that we got at the meeting. There was some that was submitted prior to meetings. Thank you. For the sake of time, I'm going to try to move with alacrity through these questions. I'm going to paraphrase them. Richard Bethel will tell me if you have a different take on them. How can we access and use the legal benefit plans? By all means, just email info@doctorscouncil.org, reply to the email that you did for this meeting, contact Dan Donlin, and we'll gladly make the connection to prior Cashman and certify you. Is there a contact person for the attorney's office that covers services like living will, health proxy, etc.? There are, but come through the Doctors Council Welfare Fund and Benefit Plan first, and they'll gladly hook you up with the attorney or attorneys. My particular question is for estate planning and will creation for a physician that lives out of state in New Jersey now. Richard Bethel, that would either be $600 reimbursed for an out-of-state benefit, or if the doctor contacts the funds office before the beginning of the plan year, then it would be treated through Richard Kay's aspects of estate planning, correct?
That is correct.
And again, doctors, a lot of these questions are answered in the attachment that we sent out with the 5 or 6 pages explaining the legal service benefits. IRS audit expenses, would I be covered as part of the plan? I think Steve Rabinovich said, correct me if I'm wrong, Steve, you said yes, if need be?
Yes, but keep in mind, that's just the legal expenses, obviously not any accounting expenses.
Because you may very well need an accountant instead of or in
I
addition.
would
to.
think so.
Thank you. Is legal fees for refinancing a residential home and guardianship for adult child covered?
Or refinancing, certainly that's something that Barry would be involved in. And for the guardianship, it would be covered under the general consultation, 2 hours plus 50 hours at $200.
Thank you. A couple of questions. What's the difference between a will, living trust, and irrevocable trust? Which one is the best instrument?
I can't opine on that. I suggested the doctor, they're entitled to a free consultation of a predetermined amount of hours, and I recommend that the doctor contact us directly and we can communicate with them.
Because
They're very specific questions.
yes, it's a drill down question. Understood. Thanks. Can an LLC or PC be included in the trust?
Yes, they can be.
And the cost of establishing a trust?
Typically, it's $300. I can't respond if they come initially without having done other estate planning, simply to create a trust. I don't know the answer to that.
Inheritance
think-
tax?
Yeah, I think for that, it might be under the 2 hours without charge, and then the $200 if it's not something specifically covered like a will.
Inheritance tax law changes and trust that can be used to manage inheritance taxes.
Yeah, it's a very complicated issue, and I'd be delighted to speak to any physician who wants to talk directly about it.
Got you. Someone interested in setting up a trust for their son, that's something that can be done. They just need to go through us and we'll hook them up with prior cash, correct?
That is correct.
Persons interested in a plethora of estate planning services, again, please contact us. We'll make the connection. My interest is real estate. I am curious in regards to tenants' rights when it comes to landlords and leases. The attorneys from prior can correct me if I'm wrong. That's such a broad question, which we appreciate, but if there's particular aspects to it, then please contact us. We'll make the connection to prior Cashman, whose attorney will be glad to drill down on any particular aspects of that. Is that fair enough?
Yes.
That makes sense.
I'd love to know more about estate planning, real estate support, and legal support options to potential discrimination in the workplace. Well, I think the first part of that question is, yes, please contact us. We'll make the connection and certify you for the estate planning and real estate. For the second part, if there's concerns about the workplace, please contact your contract administrator, at least upon the first blush, to do the assessment of that. And if need be, then we can coordinate with attorneys as a workplace issue. I have a few questions regarding disability coverage and tax-related questions. I think Richard Kay touched upon that earlier. So a couple more questions. What is the portion we doctors pay for real estate transactions? Anyone can correct me if I'm wrong. I think,
we've over this several times, yeah.
I'm sorry, Richard, Bethel, that's covered on page 2. If it's a first primary residence, I think it's 575. If it's a second, it's 650. If it's a third, it's 775.
That's correct.
Right. Can the attorney add any other fees? Again, correct me if
I
I'm-
think we've covered all of this already, Kevin,
Yeah.
in Barry's presentation. Yes.
Thanks, Steve. If we, my husband and I, assign beneficiaries to our daughters, to our accountants, do we need to have a trust, or assigning beneficiaries is enough?
Again, I recommend that they come to us for a consultation and we'll be more delighted to. They're entitled to how many free hours, Kevin? initially?
2 hours.
Right.
Two.
I recommend that they come in to us and we can opine on those issues.
Right.
There was an interesting question about changing attorneys, which Kevin, you didn't respond to. I assume that they meant within Prior Cashman, that they weren't happy with the initial attorney?
I don't know why, but I think the answer to that question is provided Prior Cashman has an attorney that also does work in that area, that if need be, we can go from one attorney to another. Would that be correct?
We have done that from time to time. It's been very rare, but yes, it has occurred.
Thank you. We're at the tail end of the questions, both of which are similar. And I think Richard K. or Barry may have touched upon this. Purchasing a small building to transfer my pediatric office. Can I form an LLC for that purpose, of forming an LLC to buy a building?
So the answer is yes, they could form an LLC, again, not covered under the primary residence. So it would be the first 2 hours and free consultation, and then the 50 hours at the reduced rate. But there are recording costs involved with forming the LLC that fall outside of that. Those costs can range anywhere from $2,500 somewhere in the neighborhood of $2,500. There are publication costs required in the state of New York.
Thank you. Just 2 more questions have been submitted, then we'll wrap it up. Would you recommend umbrella policy?
I don't know if that was for Steve or for me, but certainly an insurance agent could opine probably better than any of us. We do have insurance expertise at the firm that a doctor could call up and give the particulars, and we could give advice under the general consultation.
Thank you.
I'm guessing though, probably not, because our expertise is really more on commercial insurance, not individual insurance questions.
Thank you. And last but not least, can you provide legal advice on student loans?
Certainly, it is potentially covered under the plan. So it's something you can come into us, and I don't know that we have anyone who specializes in student loans. I don't think there are very many firms that do, but it's certainly something we can look into.
Well, I would like to say that I hope and I know that each of our members on the call tonight got a lot out of this call. We thank Richard Bethel and Richard Kay and Elizabeth Warner and Steve Rabinovitz and Barry Landsman, all 5 of you, for taking the time out of your evenings to be with us and share your legal expertise. It's greatly appreciated. I want to circle back and acknowledge Prior Cashman has been with us, not for years, but for decades. And whether it's bargaining contracts or doing grievances and arbitrations or workplace issues or through the legal service plan, I think it's very reassuring to know that Doctors Council is there to advocate for the doctors, whether it's in workplace issues or outside workplace issues on community and legislation, but also that we have attorneys that can help out and need be and specialize in issues pertaining to doctors. Thank you, everybody from Prior Cashman. This was such a serious discussion. I don't know if we try to end it with levity, like, does anyone know a good lawyer joke? But I won't get into that. But I wanted to try to bring a smile. I want to try to bring a smile to the doctor's face, because it's been a tough year. This is a very well in-depth presentation, and I'd like to close it the same way that Dr. Proscia, our president, opened it up, and wishing each of you and your colleagues happy National Doctors Day. Thank you for the work that you've done over the last year. It's not just over the last year. Thank you for the work that you do every single day. You're to be commended for it. And it's our pleasure to advocate for you and your colleagues. Richard, is there anything else you'd like to add before we end the program?
I just want to thank everyone for their questions and their attention.
And doctors, until we cross paths again, the very best to you and to your families, and keep safe and keep well. Good night, everybody.
Good night.
Good night.